Thanks for joining us on Over My Dead Body, the podcast hosted by Nicola Reeder and Carl Tate that aims to bust those myths about all things funerals and answer the questions you never dared ask. So stick in your earbuds, listen, and then send us your questions for the things we still haven't answered for you. Happy listening. So welcome back to episode 7, series 2 of Over My Dead Body. Carl, how are you doing?
I'm very well, thank you, Nicola. It's all good this week. How are you?
I'm good, thank you. Dare I ask, are we, Carl, ranty pants this week, or have we calmed a little?
Oh, we're chilled, yeah. No, we're all good again, yeah, after that little outburst last week, so we're all sweet, thank you. Thanks for asking.
You're very welcome. And are we seeing any movement in registration times? Are things getting a little bit easier?
We'll leave it at that, no.
Okay, so you're feeling better. Let's not reignite that fire again. So this week on the podcast, we have a brilliant episode about wills and probate. It's something that I get asked about quite a lot. Do you?
I do, yeah. Almost every arrangement, I must admit, we get families who say, "Oh, what about this? Do you know anything about that?" And it's always difficult because obviously that's not really our field of expertise. So we just obviously signpost people to people like Danielle.
Perfect. So we know this isn't strictly funeral related, but we have tried wherever possible in this podcast to answer the questions that we get asked with experts who know the answers better than we do. So we have a brilliant guest on this week. Hope you enjoy this episode, and over to Danielle. So on this week's episode of the podcast, we are delving into a topic that Carl and I often get asked about and very, very rarely have the answers to. In fact, we don't even know the answers. So it would be brilliant for our knowledge to try and get a bit more up to speed on this. So we are delighted to have with us Danielle Sutcliffe, who is an estate planning legal specialist from DS Wills and Estate Planning. So Danielle, welcome to the show.
Hello, thank you for having me.
Tell us a little bit more about yourself before we get started. Where are you? What's your life all about? Just give us a bit of an intro to Danielle.
Yeah, so I am based predominantly in Teesside. So I have an office in Billingham, but I advise clients around England and Wales, but I do have clients worldwide, so I can see people face to face or on Zoom. We are that sort of way in the world now, aren't we, where we can see everybody on video, which is great. So it definitely opens up the doors for my other clients. But in terms of myself and my background, the business has been going almost 10 years now. It's got a big birthday this year, which is quite exciting. But yeah, so I focus on estate planning. I don't advise in any other areas of law. It's wills, trusts, lasting powers of attorney and probate. And yeah, so that is it.
And that's quite interesting because straight away we're talking about wills and probate today, and that is legal. So I think lots of what Carl and I deal with, certainly what I deal with, there's never anything legal. You deal with a little bit of legalities in terms of kind of the right paperwork and rules and procedures.
Yeah, I mean, obviously with funerals, there are so many rules and regulations, as in, I'm sure as with planning and law side of things. So you always have to be mindful on what you're advising families and things. And always when we talk about funerals as such, there's always the conversations about we need to double check on the will, or what are we going to do about the payments? How are we going to pay for this? And it's to say, well, you have to be careful not to say. I certainly wouldn't advise anybody on anything. Yeah. What I would say, and just we need to signpost people to the right place.
Yeah, and that's ultimately what it's all about. The thing is with wills, I don't know if you're aware of this. Not many people are, but will writing is unregulated, so you do not need to be legally qualified to advise on wills. Side note. I am legally qualified to be giving the information I'm giving today, but you don't have to be. So there is a lot of misinformation out there, shall I say, coming from Chinese whispers as we do, but also from unqualified and experienced advisors. But I think we find that across the board in all different sorts of industries. It isn't just law. But yes, it's to be mindful, everybody, that will writing is not regulated. So please do your homework before you instruct somebody to make a will on your behalf.
Yeah, I know that obviously there's a few, you see them all the time, don't you? Sort of online and on the telly, sort of, when we look into funeral plans as well, so they're often tied into funeral plans. Is come with us and they're, funeral planning, and we'll give you a free will or free will writing service.
Yes.
Yeah,
I see that all the time. And I mean, I think the beauty now with funeral plans is, I know when I'd first started my business, funeral plans, they also weren't regulated. So I had so many people out there advising, and people who do what I do, for example, who advise on wills, were offering funeral plans. For me, it's just not an industry. You know your industry and I know mine, and I'm very much that way thinking. But yeah, I do think there needs to be some regulation in the will writing industry. Absolutely.
And we are definitely a podcast for more regulation, not less. I am an advocate of more regulation for celebrants. Let's get us registered too, and get some quality checks into the industry. So
100%.
I think just with everything that's in the news, certainly recently with funerals, and yeah, you're right, the funeral planning industry is now regulated. There's legislation going through government at the moment looking into the funeral homes themselves, because again, there's so many, I don't know how to say it without being, just there's so many firms that really do need regulation in their lives, definitely.
Very diplomatic.
Very diplomatic.
I like what you say about them offline.
Yeah.
He's conscious of the legals now, Nicola. That's what it is.
Well, we've now got a legal
draw the line.
So, you do criminal law, Danielle.
No, and I'll stay clear of that. Don't make me a witness either.
So we mentioned a couple of terms already, such as will and probate, and I don't know what the difference is. I get confused. So let's start right back at the very beginning with a bit of vocabulary. What's a will? What's probate?
So a will is a legal document that sets out your wishes for your possessions, your assets, your family. It effectively is a document that allows you to appoint people that you know and trust to administer your estate after your death. So your will set out who does what and who gets what. So in terms of who does what, and here's some more terminology, we've got our executors, our trustees, and our guardians. The job of an executor is to administer your estate as per the wishes of your will. They are also legally responsible for arranging a funeral, but not many people realise that. It's often just your next of kin, your closest family member, you'll be aware, will arrange the funeral, but legally it's a job that's associated with the executor. Trustees are there to usually hold on to money for beneficiaries, and then you've got our guardians, which a lot of us are aware of. That's to appoint those who will take care of our children if they are under the age of 18 when we pass away. And then we've got our beneficiaries, so that's who gets what. So our beneficiaries are those that will inherit the estate, and your will sets all of this out. Your will should make it very clear who does what, who gets what, because the idea is to make it easy for the people you leave behind. And I say this to my clients, you don't make a will for your own benefit. It's for the people you leave behind. They're the ones that need this information. They're the ones that sort this out.
So I've learned so much already. In one answer, I've learned so much already. So can those be the same people? So can your executor be a trustee and be a beneficiary? Does it have to be different people, or?
So, yes is the answer. It can be the same people throughout, and it often is. I would say the majority of families that I deal with would have the same people throughout, because when you start getting into the nitty-gritty of making a will, it becomes abundantly clear who you trust in your life, if I'm being completely honest. And there'll be a small circle of people that you trust to do these things, that you will give those roles to, but then also, usually it's the closest people to us, and then that's who inherits our estate. Now, the executor and the trustee role are often very closely linked, so it is always a good idea to have some continuity between that role. With our guardians, I generally advise my clients that absolutely have your trustees and your executors involved with our guardians, but also maybe have somebody that's a little bit more independent as an executor, so that we've got our guardians named, we've got our executors, we've got people who are looking after your children's day-to-day well-being, and then maybe one other person involved to also then look after the money side of things. It just ensures then that everything's kind of all above board, and we know that your family are going to inherit what they're due to inherit. Then beneficiaries. So there's nothing legally that stops a beneficiary from inheriting from the estate and also acting as an executor or a trustee. So yes, it is very, very common. Our executors do have to be over the age of 18, so that would stop some of our younger children, but I would say the majority of families that I deal with, yes. Usually named children if we've got them. You can deal with it all, but then you'll get the inheritance at the other side of it.
Makes perfect sense. Yeah, I get that.
Carl, have you got a will?
I don't have a will as such. I definitely don't, but I do have a funeral plan, obviously, with, being in the funeral industry. But it's something we've spoken about, but at the minute, it's quite simple. At this present moment in time, it's quite simple in my life. As I said, my wife and 2 children, that's it. Because, it'll be as simple as that, really. It'll all go to Sherry and the kids, whatever's left.
whatever you haven't spent by the time.
Yeah.
And that's a really interesting point in terms of, to what level of detail do you go to in terms of, so when we're thinking big picture about wills, we think a car, a house, a holiday home, cash in the bank. How far do you go down the line to my record collection, my jewellery, my bed linen, my nightie? Like, where do you stop at stuff?
Where to draw the line? And I do get asked this a lot, because you could go on forever and a day trying to account for and every single asset that you've got in the world. It's nigh on impossible. So generally, we would go through specific gifts first and foremost. So if there was anything specifically like a record collection or a vase or a family heirloom or something that specifically needed to go to an individual, we'll cover that off on its own. Some people like to gift houses on their own, specific bank accounts, cash amounts, whatever that might be. But then there'll be a phrase within the will that accounts for your residuary estate. And your residuary estate is effectively anything that hasn't been specifically gifted earlier on in the will. So that's kind of our mop-up clause. Now, the majority of estates that I would say have the main focus as the residuary estate, because it's not advisable to try to list every item that you've got and gift them like that. If you do have a lot of specific items, then I tend to recommend something called a memorandum of personal chattels, and that is a document that sits alongside your will but is referenced in the will itself. And it goes into a lot more detail, could be 5 pages in length, however long you want it to be. But it's an easier way to kind of administer that and read it through for your executors. It just keeps it a little bit more separate. But yeah, it's difficult. Every family is different, and it depends what means something to you, because something doesn't necessarily have to have a physical value, a cash value, for it to be important and it to be something that you want to gift to somebody. And it's important that we capture those wishes.
I think it's absolutely spot on. Obviously, putting a list together sounds good. It is a good idea. Obviously, it does work. And I mean, obviously, within the funeral industry, we always find that, unfortunately, death sometimes brings out the worst in people when it comes just to everything, from everything start to finish. Do you find that's the same within the will side of things? When you are reading, I mean, it must get quite intense sometimes reading a will out, or even putting one together.
Yeah, it really does. So we have to have lots of difficult conversations with both. So the person who makes the will is called the testator. So we have very difficult conversations with the testator initially, depending upon family dynamics and where they want assets to go. And yeah, we have to have difficult conversations. And then it comes full circle again when that testator has passed away, and then we're dealing with the family. And we sometimes have to give that news to certain family members that they aren't inheriting what they maybe thought they were going to inherit, or the wishes are different. But yes, you are right. Same in my industry. See, you can see a very different side of people after the event. So the will is there for clarity, but it doesn't mean that everybody will be happy with what's in the will, ultimately.
And I think maybe in the same way we say to people, talk about your funeral, talk about your wishes, talk about your plans. If you think there's going to be something contentious in your will, maybe try and have the conversation, or understand how people are feeling, what their expectations are. And nobody should ever expect to inherit anything. If you inherit something, you're really, really fortunate, but there should be no expectation. But have the conversation with your family so they're at least maybe prepared for, if you're going to leave it all to the cat's home, you're not adding to their distress when they're grieving.
Yeah, I completely agree, and I am such an advocate for that for my clients. And I will ask them if they feel it's appropriate within their family circle to have those open conversations with family members. It just means that there's no surprises, there's no shocks, because we're already dealing with an incredibly emotive situation. You're dealing with the death of a loved one, and then to have to find yourselves maybe in an argument over assets and things like that, when that could be resolved earlier on if we're just willing to have open conversations. It's not appropriate for all estates and all families, and I understand that. But where possible, yes, I'm certainly an advocate for it. You are dead right, though. There isn't an obligation in England and Wales for you to leave your estate to anybody in particular. There are some countries around the world that dictate where you need to leave your estate to through their provisions. We don't do that, but there is an assumption, shall we say, that there are almost like a hierarchy order of people who would ordinarily inherit from the estate. And if that doesn't work out as somebody would expect, then yes, it can cause upset on the other side. But in situations where I have a family that might want to exclude maybe a child that they're falling out with, that they're estranged with, or another close person who ordinarily might have expected to inherit, I advise that we include things like exclusion statements that gives the client's reasons, the testator's reasons as to why it is they've not left to that person. It just gives a little bit more background after the event, and it can make things a little bit easier when it's drafted in the right way.
I think that sounds spot on, because it then gives that person, as you say, that clarity, almost that closure to say, right, okay, that's fine if that's what's been said, and you can sort of then potentially move on rather than it's just that completely, the unknown as such. But is that the same in Scotland then? Because are there different rules in Scotland about sort of hierarchy as well?
There are different rules in Scotland, and I'm actually only trained to discuss law under England and Wales. So if you did have assets in Scotland, believe it or not, you do need to have a Scottish will in place, because the laws are slightly different around the inheritance side of things. Yes, more so around inheritance tax.
Oh, gosh, which is a whole other. We are definitely not getting into inheritance tax today. Let's park that. Although that might be another
podcast.
We'll get you.
It's another podcast, absolutely.
And specifically, maybe how to minimise inheritance tax is the word.
Yes,
but that's at the top end when you start paying inheritance tax. When people perhaps have fewer possessions, is there a point at which it costs money to have a will written, unless you go for a free one somewhere? Is there a kind of a minimum amount that you need to have in an estate to make it worthwhile having a will, almost, if that makes sense?
It just makes sense, but it's a really difficult question to answer because every family is different. So I will have people contact me and say, do I really need a will because I don't have anything to leave? But then when we actually drill down, and I'll say to them, well, what do you have? Do you have children is usually my first question. Do you have children? If you do, and they are under the age of 18, you should have a will in place to appoint guardians, even if you made that will for no other reason. Do it for that. You might not have possessions to leave, but you've got your children and you want them to go somewhere. There's not a fixed amount that I would say, though, because, and this is almost where it ties back to what it means to you, what your personal possessions mean to you. Because sometimes I will speak to people who will make a will just to avoid the intestacy rules kicking in, because they know that their assets, whatever that might be, however big or small that might be, it's to stop it from ending up with somebody that they ordinarily wouldn't have wanted to inherit. So it's difficult to say if there's an amount at which it becomes worthwhile, because it's different from person to person.
Yeah, absolutely. And then I guess we start to move into what happens if you don't have a will. If there's nothing in place, what happens then?
So effectively, the government have written a will for you, and it's known as the intestacy rules. So they do have a hierarchy of people who first and foremost can come forward to be appointed as your personal representatives who do the same job effectively as an executor would, but you are appointed through like a court rather than through your will. But then there is an order at which people would inherit. So first it's spouse, then it's children, then grandchildren if we've got those. If not, it could be parents, it could be siblings, it could be nieces and nephews. It goes out like a big wide family tree. But I speak to so many people that will say to me that they might not have a few of those people in that order. So they know, let's say, that their estate will end up with a brother or a sister, but they've got no relationship with that person. So they'll say to me, I want to make a will and I don't immediately know where I want it to go. I just know I don't want it to go there. So for some people, the intestacy provisions would mirror their wishes. In a lot of instances it does. And it does work for some people, but I still wouldn't recommend relying on the intestacy provisions instead of having a will, because your will can do so much more than just that.
So that's wills. What's probate?
Probate. So I get asked this all of the time, and I also get asked, do I still need probate if I've got a will? So it all kinds of comes hand in hand. So probate is the actual legal process of getting permission to administer the estate of the deceased. Probate is used where there is a will in existence. There is a slightly different process, almost the same, but it's called letters of administration for those that don't have a will in place. So I'm just going to use the term probate in general to kind of cover off the general dealings of someone's estate. So your will appoints those people, or they are court appointed if you don't have a will. And probate, you get a piece of paper called a grant of probate that is administered by the probate registry that your executors will then use to start administering your assets as per the wishes in your will. So that could be going to the bank and saying, I need you to release the funds from this particular account, or it could be speaking to pension companies and that sort of thing. So the will does not stop the need for probate. Probate is determined upon the type of assets in your estate. The will doesn't have a bearing on that as such. The will just makes the process easier because we already know who is doing what. We have already appointed our executors. They know that it's their duty to take the estate through that process.
So, depending on your assets then, what sorts of things are likely to go through probate? Who would be applicable?
Yeah, who administers that? Is it who gets that probate? Who gets the option to go and do it?
Yeah.
You know.
So it's a duty, it's a role of the executors to apply for probate. But they need to determine whether or not probate is required, because it isn't required for all estates, and that's what they want to do first. So for smaller estates, sometimes you can get away with not requiring a grant of probate. Now, I know you might ask me here, well, what's a smaller estate? I can't give you a number. The reason being is because most banks have got different thresholds for at which point they might request a grant of probate. So what I would say to somebody who phoned me, for example, for advice on does this estate require probate, I would be saying, please go to all of the institutions that you're aware that this person holds assets with and ask them if they require a grant of probate before they release the estate, because you might be able to avoid it. However, if a person owns a property or land, there's usually no avoiding probate. The only way that you could avoid probate initially is if that property was jointly owned, because it passes to the other person that you own that asset with, i.e. the property, without the need for probate, or some trusts will avoid the need for probate, but it's not a guarantee. So I can't give you a number, but if you've got savings, check with the institutions, do we need probate? If you own a property, it's almost certain that at some point, if we're dealing with a couple, we might get away with not requiring probate when the first spouse dies, but we will need it when the second spouse dies, because the land registry will not allow us to do a transfer on the title register without it. So, really, before you start making an application for probate, do your research, contact the institutions, and yes, it might be a bit of a slog to contact everybody, but you could just save yourself having to go through the full process of probate by doing that.
So again, when we get sort of sitting down with families, and at the end of the conversation, it's the do you think we need probate? Do you think we need to do this? When somebody does apply for the probate status, because one of the other questions is, do you know how long that takes? It's like, how long does it take?
How long is a piece of string? I wish I knew that answer. So, with probate, the problem that we've got is that you have to contact all of these organisations, because we need date of death values on assets before we can apply for grant of probate. So that in itself is completely dependent upon how quickly these institutions get back to us to give us the information we need for the probate form. However, once all of that information's being gathered and we know about somebody's estate assets and any liabilities or debts that they've got, and we've completed the probate form, on average it could be maybe 14, 16, 20 weeks we've seen, but that isn't a guarantee, because sometimes the more complex estates will take longer. Estates where they might have, and I know we're not talking about it, but inheritance taxes cause delays potentially in estates. The grant of probate itself isn't usually the biggest delay in the process, believe it or not, which people don't realise. The biggest delay is obtaining the information you need at the start to be able to actually apply for the grant. And then at the other side of it, it's actually going back to these institutions and saying, here is the grant. We're now in a position to be able to gather those assets in. Can we do so? And it's that. And then we need to have clearance from HMRC and things like that to be able to actually finalise an estate. So every estate is different. It's really difficult to kind of give you a fixed time frame. And some estates are definitely done much sooner than others. Some can take years, the more complex ones.
So when somebody asks me that question, what I'll do is I'll just advise them to come and see you.
Yes, and just say, Danielle will answer that question for you, absolutely. Cool. Yeah, don't get involved in that.
But just while we're not talking about it, in terms of inheritance tax, I know there are lots of conditions on what your particular circumstances are, but it starts round about, is it 325,000?
Yeah, you absolutely bang on. So,
not that I've been looking it up or anything.
No, not at all. It was not any research. So, there is something called a nil rate band, which is worth £325,000 per person. If you are married, any assets that you transfer between one another on first death is exempt from inheritance tax. So what you'll often see headlines in the news that say a married couple are allowed £650,000 in assets before inheritance tax becomes applicable. That is kind of correct. It just depends upon what we're doing on first death. But yes, we've got £325,000 per person. There is also another relief that is applicable to some families, which is called the residential nil rate band, which is worth another up to a maximum of £175,000 per person. But there are more constraints with that. So you need to be gifting a property down to direct descendants, and it needs to be a property that you own on the date of your death and you've lived in at some point during your lifetime. And there's also a cap on your estate value to be able to claim that additional allowance. And the estate value starts to change when you get to 2 million. But yes, the first point that we always look at is the 325,000. If you're under that, you don't need to worry.
2 million, are we?
I think 2 million might be a bit.
No. That might be a bit beyond us. So.
Yeah, it's. You wouldn't be worried, would you, if that was your estate size?
I'd be having somebody to sort that out for me. I'd have a man that does that.
Absolutely.
But it just shows when you get into wills, into probate, into inheritance tax, into then where you've got to apply to for the money pensions funds. These are difficult institutions, difficult, complex processes. So actually, for whatever your estate, just get the right people, the specialists involved. Don't try and do it for free via one of the charities. Try, as lovely as that is, try and get the proper advice that you need for your particular circumstances?
Absolutely, because I speak to so many families that will come on and they'll say to me, my wishes aren't complicated, my family isn't complicated, and then they will start talking, and then something comes out that would cause an issue with their estate, and then we get into the ins and outs of it, and they'll say to me, oh, I've not considered that before, or this is the first time I've spoken about this. But that's why I always have an initial consultation with my client. It's to go through that sort of information, because the wishes in general might be straightforward, but it's how we actually get to that point and everything we've covered in between, just to make sure that we've done everything we needed to do. Because the thing is, with a will, you don't know if it's right or wrong until it's too late, because the person's passed away. That's when your will kicks in. So that's why it's so important to seek the right professional advice, so that you know that your estate is being advised on correctly, and ultimately that the advice that you've received is insured.
Genuinely, I think that's really good advice, because obviously when we started this podcast, it was really just so people would start talking about death and funerals. And then since we've started, it's just gone, it's sort of like a snowball effect, where we've had all these different people come on and talk about every sort of angle of funerals, and this is a huge part of it, because it really does hinge on quite a lot of things being in place and people putting their wishes down onto paper, but having it done properly, so you've got that sort of stamp of approval. It's really a proper document that can be put forward.
And I think it's like we've talked about having your funeral plan in place, having your will in place. We might just touch on lasting power of attorney, those kind of things that you can then, it gives you peace of mind. I think it's when we were talking to Dead Good Legacies and to Katie Costello earlier in this series, and they were just saying, actually, when you've got all of that in place, it is actually that weight off your shoulders, and you just think, if anything did happen to me, my family's okay. They know where to go to be able to follow my wishes, to get the help and support they need for managing my estate. It's just a bit of a weight off your mind, really.
100% it is, and that's the reason for doing this. Ultimately, it is that peace of mind, and I think that is the most common comment that I receive from somebody after they've signed their will. They will say, it's just a relief, it's a weight off my mind, I know everything's now in order, and I just know that at least it's a starting point for somebody. They've got a document that they can go through. And touching upon funeral wishes there, I always ask my clients when I'm taking will instructions if they've got specific funeral wishes, if they've got a funeral plan in place, and I will directly reference that in the will itself. But I'll always say to my families, please, please, please speak to your loved ones if you've got specific funeral wishes, because in practice, what I tend to find, and you might find this as well, Carl, is that you'll have somebody will pass away. They'll arrange the funeral, and then they usually go looking for the will after.
Yeah.
And what I say to my clients is, please make sure that if you've got specific wishes, you've made them known, because I don't want your family to arrange your funeral and then find your will at a later date and the wishes are completely different, because there's nothing we can do about that. So we do have to, it's important that we have those conversations. And I say to my clients, if you've got prepaid funeral plans in place, please make sure people are aware of it. But it just makes that process easier. It's one less thing for the family to think about. It's no longer a decision that they are having to make. It's a decision that the deceased has already made. You're just putting it into place.
Yeah,
absolutely. So Danielle, you've mentioned probate. And there was a couple of questions that Carl and I were just thinking about before the service. So I think the first one I'm going to ask you is, what happens if people need to access funds in the estate? So I'm thinking maybe to pay for a funeral, but also if there are children and they need to access funds to feed the children, to pay the mortgage, to do those kind of things. Can you get to money while the probate process is happening?
That is a really good question. It is one that I get asked a lot by families after somebody's passed away. The funeral, yes. So I'm going to start with that. So the funeral is considered an estate expense. It's a testamentary expense. So a lot of our banks will allow the executors, even if the account has been frozen, to go into the bank with an invoice from the funeral director, and they will pay the funeral directly from that particular bank account, so that the funeral director isn't having to wait, and obviously it's delaying everything for the family as well until probate has kind of come through. But yes, our banks are really good and they will allow us to do that. In terms of paying other bills, once a bank has been notified of a death, they will freeze that bank account, which will stop things like your utilities being paid, it will stop the mortgage being paid. But what should happen is, and this is all part of the general process of dealing with affairs after somebody's passed away, and it's about who do we notify. So you need to be notifying as an executor mortgage companies, we need to tell the utilities, we need to tell the council tax, everybody who's got an interest in this person, usually through direct debits and things like that. They need to be made aware, because if we put them on notice that this person has died, a lot of these organisations will give the family breathing space. They know that there's a formal process. They know we need to wait for probate. So the mortgage knows that it'll get repaid. We'll just put a hold on it for the time being. But I am an advocate for people having life insurance. Now, I'm not a life insurance advisor, I have to say that, and I don't give life insurance advice. But the reason I'm an advocate for it is because it's there to help in situations whereby somebody's passed away and we quite quickly might need access to funds to pay things like mortgages, or to pay for children, or to cover expenses, whilst we're waiting for banks to release money through probate. So I am a big advocate of having those sorts of provisions in place as well. And for me, they come hand in hand with your overall estate planning, because ordinarily, once the account, other than things like the funeral, potentially other testamentary expenses, once the bank account has been frozen, they generally won't be releasing those funds until they've seen a grant of probate, and that could take months.
Yeah, no, is a good advice with obviously life insurance. So I'm worth more dead than I'm alive.
Yeah, me too.
We all are. We all are.
The kids are going to be all right.
Steve, you didn't hear that. I'm worth more alive.
Yeah, the kids will be all right. But I know it's almost like it bridges that gap, doesn't it? So the insurance is obviously, death certificates are produced, sent straight. Obviously, as you say, the banks are frozen. But the life insurances pay out. Usually, they are very good, the life insurance companies, and do pay out relatively quick, which sort of does help bridge that gap for that time being, which is a good thing to do.
Absolutely.
Just talking about what you're worth dead. What happens if you die owing money? So I'm thinking maybe a specific one would be where you leave a house to your children, but there's still an outstanding mortgage on that house. What happens in that scenario? What happens if somebody dies with a credit card debt? Do their beneficiaries inherit that debt? How does all that work?
So I speak to lots of people who think that your debt dies with you. It doesn't. Not all debt dies with you, I should say that. So mortgages would need to be paid off. And that's often why it's advisable to have life insurance in place to clear that mortgage, so that if you do have a family, that they aren't left homeless effectively, because we've just got the equity that's in the property, whereas with your life insurance it would clear those bills. If there are credit card debts, things like that, again, when I'm dealing with probate, I make a note of our liabilities. We will contact any creditors and make them aware that there's been a death, and then they will tell us, because not all companies will actually call a debt in, but they will tell us whether or not they are calling that debt in. The debt itself does not pass on to the family, the executor. So it would be paid out of the estate. If there was not enough funds in the estate to clear it, then the debt effectively bankrupts the estate, and it just means that there's no money for the beneficiaries.
Carl and I are making little notes here about, okay. Now I need to actually declare what my credit card debt is.
That's fine, I'm clear.
Yes.
Okay.
I know, and I ask my clients during the will instruction process, I go through all assets and all liabilities, and then I make them aware that liabilities will be deducted from your estate, and do we have the provision to pay them off? If you die tomorrow, can your debts be cleared through things like life insurance and that sort of thing? So yes, it is an important one. Now, people will often say to me, well, how do creditors know that somebody's passed away? Well, it's an obligation of their executor to notify them. One thing that families can do is put a statutory notice in the London Gazette. When you put that statutory notice in place, it's basically given information to all creditors. They can check that notice. Has somebody that's got a debt with me passed away? And if so, we know that we need to get in touch with the estate to claim that debt back. So it's effectively putting everybody on notice that there's been a death, because it isn't always possible to know the ins and outs of what somebody's got. It could be a really small debt that we've got no communication about. But as an executor, it forms part of your obligations. And if you've put a statutory notice out there, you can almost effectively tick that box and say, we've tried to notify everybody we possibly could through all means necessary.
That's incredible. That's something I never knew about. Definitely no. Yeah, it's really incredible.
Crazy. Absolutely crazy. So if somebody just wrote on a bit of paper and stuck it in a drawer, I want all of my possessions to go to the Dogs Trust, is that legally binding in any way? Is that what's going to happen?
Or if they write, this is my last will and testament on a bit of paper.
Or if you buy one of those packs from WH Smith. So are they like legally binding?
So the packs, a homemade will of any description, be it a pack that you've got from WH Smith or the post office, I know that they've got them as well, and you filled it in, or whether or not you've got a little scrap piece of paper and you've put your wishes on there. Ultimately, we need to make sure that your will is a valid document. It needs to be dated, signed, and witnessed by 2 independent witnesses. What I find with homemade wills is that they often fall down on the witnessing side of it, because people don't realise that it needs to be witnessed. And those witnesses have to be physically present when you sign your will. It can't be that you've scribbled this little last will out and then you've gone next door and you've said, oh, I've just signed this, can you just sign that to say I've signed this? They have to physically see you sign the document, and all of these things are checked. So at the point of probate, they look at obviously the contents of the will, the condition of the will, and if they believe that there are potentially any question marks. So one of the things that we often get asked about is the colour of pen that's been used. So how come the testator is signed in black but the witnesses have signed in blue? Can you confirm that everyone was present together when they signed that document? Because the fact that they've used 2 different coloured inks makes us believe maybe not. So then we might have to go back to witnesses and say, can you confirm categorically that you were in this room when this person signed the will? And also that you meet the relevant requirements for a witness, because we can't just have anybody witness a will. You've got to meet the certain requirements. So yes, a homemade will can be legally valid if you follow the steps correctly, because it is prescribed in law how a will needs to be signed. But they will often fall down on those things because people don't realise the importance of correctly signing and witnessing a will.
I think it's a really good point to make about those wills and things, because it's sort of same with funerals as well. When you have a family member will say, oh, well, yeah, well, my mum or my dad told me that this was the favourite music, and then someone will say, well, we'll prove it. Where's it written? And if it's on a piece of paper, it could be written. And then what they'll say is, well, that's not my mum's handwriting, that's your handwriting. Oh, well, she was telling me as I was writing. Yeah. And then all of a sudden, it causes so many problems. Whereas if you have a funeral plan or a proper request of wishes down that's held within the funeral directors, it's sort of it can potentially cause so many different problems.
Yeah, absolutely. And I think in terms of kind of revisiting what we talk about this with funeral plans, kind of don't write it once and then never look at it again. There might be different songs, or there might be new poems, or there might be new bits to add to your story, or there might be a new crematorium built. So just kind of every so often revisit it. I guess it's the same with wills, because you may have taken on more debt, lost more debt, changed houses, bought a new car, splashed out on a speedboat. So what frequency do you need to kind of be having a look at it?
So industry standard, we recommend every 3 to 5 years, or whenever there's been a significant change either in your family or your assets. So if your assets have gone up or down in value quite significantly, or perhaps you've inherited an estate from somebody. It could be that you then need to revisit your will as a result of that. But that's the general industry standard. So I offer free will reviews to anybody that's got an existing will, and I will just check through that. So it could be for an existing client of mine, it could be for somebody else that's had a will drafted 20 odd years ago, and they just think, is there a deadline on my will? Is there a time frame? Does it automatically invalidate after a period of time? It doesn't. Your will would remain valid if it's a valid document, but yes, we should absolutely be updating the will, or just at least reviewing it, making sure that the provisions still stand regardless of said change that's taken place. So recommended every 3 to 5 years, or if there is a significant change.
So when somebody does come to you with that and says, look, can we just revisit this? Nothing's changed, but I just want to check everything's still okay. Do you put a stamp on there, or sort of a signature to say that this document was checked on, January the 1st, 2026? And then that's a sort of, because you could have families say, well, that was written back in 19 whatever, and well, it's changed since then. Is there anything that sort of suggests that yes, it was revisited and it's still applicable?
No, so the will wouldn't be stamped, but for myself, I would assume that professionals would do this, or something to this degree, is that if I was seeing an existing client, for example, who I've already got a client file for, that was asking me to review or revisit an existing will, I would have notes documented from that. So whenever I do an update, a will review, I will take an updated version of their estate assets. It could be that it hasn't moved at all, that everything might be the same, but I will take an updated version and I will save that on file, so that if in the future anybody ever queried, well, was this will ever reviewed again, I can say, well, when it was last looked at, this is where we were with the estate assets. It's also really helpful to hold that information for our executors. So even if you weren't actually getting somebody to update your will or to review your will, just be mindful that if you're changing bank accounts, or you're changing professionals that you're dealing with, or anything like that, pension providers, because they change over the years, life insurance providers, keep a record of it and make sure that your own records are up to date. Don't let our executors go in blind. Give them something to start from. I think that's really important. But no, to answer your question, it wouldn't officially be stamped or anything like that. It would just be, I've reviewed your will from way back when. It's still a valid document as it was the day it was signed.
Trying to sort of keep your own admin up to speed as well.
Yeah, absolutely. And in terms of, without giving away any professional confidentialities, and I'm not asking you to give us a price for your services in a public domain, but roughly what might people pay to get their will written by a professional? And then are there ongoing costs? Is it like a subscription, or once you've paid for it and it's written, is that you paid? How does it work?
So that is a really good question, and I do get asked that as well about ongoing costs for wills. I'm happy to disclose my fees for wills, because everything I do wills wise is fixed fee. So if you need a simple will, if it's a single will for a sole person, my fees are £180. If it's a mirror wills I should say, 2 people, it's £280. Generally speaking, average cost wise, you are probably looking at, especially in the northeast, although it's different countrywide, pay a little bit more down south. In the northeast, you are generally looking at somewhere probably in the region of maybe £160 to £200 for a simple single will. That'd be about your starting point. In terms of ongoing costs, there's no ongoing cost to the will itself, but if you opted to have your will stored securely with a professional that charges, so I do offer secure storage facilities, but I do charge for that, then there would be an ongoing charge for that storage facility. The only other charge that could be applicable would be if the will itself needed amending at any point in the future, then there would usually be an amendment fee to update that document, but there's no ongoing charges standard. So if a single client came to me with straightforward wishes, and I put a will in place and they were storing their will at home, they would pay the cost of the will and that would be it.
So there's just one other phrase we've touched on today that I don't want to spend a huge amount of time on, because it kind of feels slightly away from wills and probate that we've been talking about. but we have used the term lasting power of attorney, which often comes in later on in people's lives, but actually I'm quite an advocate of everybody should have a lasting will of attorney. So how does that all work?
So that's a perfect overview, because I see this in practice. So people will say to me, I'm too young to make power of attorneys, or at what point do we need for them to kick in? They are generally associated in the later stages of life, shall we say. But yes, I believe everybody should have power of attorneys in place. So power of attorneys are documents that are separate to your will, and they are used during your lifetime to allow your chosen attorneys to make decisions on your behalf if you lose the mental capacity and the ability to make those decisions for yourself. So it could be on property and financial affairs, for example, which is one lasting power of attorney document, or it could be on health and welfare, which is another lasting power of attorney document. You can appoint the same attorneys across both documents. You can appoint different people. What is crucial is that your power of attorneys will only be used if they are needed, and if is the crucial word here. Because I say to my clients, I hope you never need to use these documents. I truly hope you can always make your own decisions. But what I can guarantee is that they will be the most important documents you make for yourself if they are ever needed, because it ensures that your life decisions can continue. Whereas with our will, it's coming to all of us. We're all going to die at some point in the future, as blunt as that is. All of us will need to use that will. That's a guarantee. But you make it for the people you leave behind. Now, the difference here is that the powers that you bestow on your attorneys end on your death. And usually at that point, your will would kick in and your executors would take over. Often the same people, but they are doing different roles. And that's important for people to understand.
Yeah, it is. I mean, I've got, because you mentioned the two sides of things there. So there's the financial side, but there's also the medical side, isn't there? So that it's all that makes the medical decisions. And I've got a few of those, unfortunately.
And I think the way I've explained it to people when they've kind of said, why would you need it when you're younger? I kind of think if myself and producer Steve, heaven forbid, were in a car crash somewhere, and we were abroad, and we knew we had the funds in our estate to get us the best possible medical care, to get us home, to get us as comfortable as we can, but there was nobody who could access those funds to be able to get us that care, then it doesn't matter.
You have to put me down.
No, I have to put you down. You are not having my money. Not that I've got any, but you're not having it. The big word is if.
That's right.
If.
Yeah.
But yes, you are right. If you ever found yourself in that awful position, then yes, there's nobody legally allowed to access your funds. And there is a common misconception amongst families that spouses or children, whomever you consider your next of kin, are able to make these decisions on your behalf if you lose capacity, but without a lasting power of attorney document, they are not allowed to make those decisions. They can't just turn up to the bank and say, I need to start withdrawing money. Mum's lost mental capacity, I need to pay her bills. That's not how this works. They would need to have a legal document in place. And you want to be making these documents as early as you can. And the reason I say that is because nobody knows what's around the corner, and power of attorneys can only be made whilst you've got the capacity to make those documents. After the event, it's too late.
Where they said you cannot just turn up to a bank and say, I'm Nicola's power of attorney.
Yeah.
I need 50 quid because I'm going on the left.
Exactly.
No, I get that.
You get it?
Fine, yeah. All good.
Okay, all good.
So where would we get these documents from then? Is it somebody just contact you, someone like you, or how are they obtained?
Yeah, so power of attorneys you are able to do them online. Like you can make a homemade will, you can make your own power of attorneys, but there's a lot more to them than just the document themselves. So it's really important that you do seek professional advice before making a power of attorney. So yes, you can look online, you can look to do them yourself, but my advice, of course, would be speak to a professional.
Yeah, I fully agree. It's the same when we talk about anything, whether it's regards to financial side of things or funerals. You know, like I say, it's all right done on the back of a fag packet, but really, it's not what it's worth. You know, you need to do it properly and with the professionals, definitely.
Absolutely. So we have covered so much tonight, and I feel like we could carry on talking forever because there are still questions in our heads where Carl and I are going, but what if? But what? So I know there's loads more. We might come back for part 2 of Danielle's episode.
Yeah.
But if there were kind of 3 key things that we've talked about tonight that you would really advise our listeners to go away with and think seriously about, what's the kind of 3 top tips where people can help themselves based on what they've learned in this episode?
Number 1, make a will. It doesn't matter what you've got. Please speak to somebody about making a will and make sure it's professionally drafted so that you know that at the time that that will is needed, it is going to stand up because it is a legal document. Be open and transparent and have conversations with your family members. It's so important that they are aware of what your wishes are, that they know what is coming next. It is already a hard enough time for them dealing with the death of a loved one to then be almost like rabbit in headlights. They don't know where to start. What do we do next? And I am such an advocate for what I would refer to as a death file. So, yeah, look, yes, absolutely. Carl's on board with this. Yeah. So, a death file is exactly that. A file with all of your important documents in, but not just your important documents. It's about your professional contacts. So having there things like your will if you've got one, your power of attorneys if you've got those. Anything to do with life insurance, your bank accounts. You don't have to put statements in there, but at least have it covered down who you bank with. You might not want to include sort codes and account numbers, but at least give them an idea as to who they need to contact. Pension providers. And then we talk about professionals. So is there somebody that's advised you on your will? Have you got a solicitor, a legal advisor? What's their details? We need to know who your financial advisor is, who's giving you that sort of advice. Do you use an accountant? Anything else like that? Cover your mortgages, cover your liabilities. I'm such an advocate for keeping that information because without it, and I get so many calls about this, where do I start? Mm-hmm. Where do I start? My loved one has passed away. I'm dealing with that. I'm trying to arrange the funeral. I'm registering the death. What do I do next? At least give them a head start and put everything in there and keep that up to date. And I think that that would be my takeaway. Have that information kept somewhere nice and safe and secure, but also tell your family where your death file is, because it's no good tucked out of the way in a safe that nobody can access if nobody knows it's there. We need to make them aware of where it is and have the ability to access it.
And we would just add on the end of that, that's incredible. Also put in your death file who you would like your funeral director to be, whether you want to be cremated or buried, whether you want a church or a crematorium or a beach, what music you want, what stories you want telling about your life, what colours you want people dressed in.
Yeah,
all of those things. Do you want to be cremated or buried in your wedding ring or not? Because Carl has a story about that. So just make sure everything is in that file and people know where it is.
Everything. Absolutely, could not agree more. And I say, if you've got funeral plans or you've just got your wishes written down on a piece of paper, put all of that together. And just as long as your loved ones know that upon your death, they need to find this file and it will give them a step-by-step almost of everything that they need to do. Absolutely.
Danielle, you've been amazing tonight. Thank you so much. And can I just shout out to David Knowles, who was on the series a few episodes ago, because he put us in touch with Danielle and said, you love her, she'll be brilliant for an episode. So thank you to David for recommending. But you've been amazing. So how do people get in touch with you if they wanted to have a conversation with you?
So they can contact me through social media or through my website. So it is dswills.uk. And that's across socials and on my website. But you can contact me by email, telephone, however, really.
Perfect. Yeah. And we will put all of your details on the show notes link as well, so people can get in touch with you.
Thank you very much. And thank you so much for having me.
Oh, thanks for everything. It's been brilliant.
It's been a pleasure.
Yeah,
thank you. Thank you so much.
Thank you.
So thanks to Danielle for a brilliant episode there. I am sure you're all coming away from that with your heads spinning about what you do now to try and put your wills in place. If you do have any more questions or queries, get in touch with us or Danielle, or if you just want to chat to somebody about things you're not sure where to go, of course, give us a ring anytime. So that's about it from us for this week. Carl, anything on the cards for you at the moment?
Yeah, well, it's always busy, isn't it? Unfortunately, the funeral side of things, we're very busy. So just dealing with day-to-day funerals, and then obviously, yes, the mayor side of things.
Are you the mayor?
I am. Yeah.
Wow, didn't know that.
Yeah, we've just put in a bid to become the town of culture. So this has just been obviously released. So Richmond is putting a bid in to be the town of culture 2028. So watch this space. Yeah.
And you, as the most uncultured person in Richmond, are leading that bid, are you?
It would appear so, yeah.
Oh, God, we've got no hope. So if there is anybody out there who's slightly more cultured than Carl and would like to lead that bid for us in Richmond, of course, please do get in touch. Well, that sounds very exciting. Keep us posted.
Very, very exciting indeed. How's things with you? Have you got much going on?
Same as you, really. Lots of funerals in the pipeline, and hoping to keep dry because bloody hell it's rained the last few days. So, just looking forward to getting through January and into February. But just a reminder to everybody, I think we mentioned it on the last episode of the show, we aren't doing this for the glory or for the awards, but if we can get our message out there to more and more people about making it easier to talk about death, then our job is so worthwhile. So please, if you think this podcast is worthy of any recognition, you can nominate us for the Good Funeral Guide Awards. You can find them online at Good Funeral Guide, and they have awards with a number of categories, and I think there's one about education and communication in the industry. So, and of course, the British or UK Podcast Awards, they're probably beyond us at the moment, but you never know. If you wanted to nominate us for anything, we'd be honoured if you would do that to help us get the message out. So go away, have a brew after that episode. No doubt you need it. We'll be back next week with an episode, as we mentioned, we know won't be for everybody. It will be touching on baby and child loss and how we put together funerals for those who are very young and have been taken far too soon. So just keep that in mind when next week's episode drops. Thanks for listening, and we'll see you soon.
Cheers, guys. Thank you.
Thank you for listening, and we really hope you enjoyed and were inspired by this week's episode. Remember that you can get in touch with us anytime to ask a question, offer to be a guest, or to request that we bust a particular myth. You can get in touch via any of our social accounts over My Dead Poddy on Facebook, Insta, or TikTok, or you can drop us an email at overmydeadpoddy@gmail.com. Just a reminder that whilst all of us work in the funeral industry, none of us are fully qualified grief counsellors. And therefore, if you've been affected by any of the issues that we've discussed today, we highly recommend that you seek out professional or medical support to help you with those conversations. Should you need any support, please do get in touch and we can hopefully signpost you in the right direction, but we can't offer those services ourselves. Thanks for listening, and we can't wait to bring you the next episode.